Meanwhile, the final session here, last but not least, still digital heroes, I'm sure, each. If you look at them generationally, they almost certainly are better than me, I suspect, digitally. Now, so let me introduce you. We have Alice, Simon, who am I looking at? Julia, Alice, Simon, and Julia with us here tonight. They will run through a little case update for you, and by the end of this, I think you will be very well informed. It's not going to be in the usual run through every single case one by one. There's a slightly new approach here today. Okay, so I hope you enjoy it.
Thanks, Roland, and thank you for saying everything I was going to say in my introduction. Moving on. Next slide. So there have been some really interesting and important cases over the last 18 months. We're actually going to try and talk to you about 30 cases in 45 minutes. So as Roland said, we're not going to do the usual grind. We've separated them into these 5 categories, and then we're going to hopefully have time to finish off with the usual quiz. So strap in and we'll begin. So I'll begin by talking about, firstly, the importance of registration. There have been a number of cases this year which have demonstrated the limitations of unregistered rights, such as passing off and unregistered community designs. So what I'm hopefully going to demonstrate is that there are those limitations, but also it's still possible to rely on those rights in certain circumstances. On a side note, I thought I'd mention, even if you get to the start of proceedings and you haven't necessarily secured the right registrations at that stage, it's not too late. A strategy that we've run in 2 cases very recently, Free Prints and the Hendrix against Lidl case, is we've initiated proceedings and then have actually, so for example in the Free Prints case, it was originally a passing off case, and in the proceedings we applied for a new trademark registration, and actually that was what we ended up being successful on, and not the passing off case. So you can do it at any stage in the proceedings, and that's a similar tactic that we've used in the Hendrix case. So starting off with our first case, this was a passing off action. Both the claimant and defendant sold bodycon and bandage garments under separate brands. And the claimant relied on, there's going to be 2 images there. Sorry, you can't see that very well, but the claimant relied on various elements of its brand and the overall get-up and the kind of things it was doing as a business. And the defendant used identical models, used identical photo shoots. As you can see on the screen, you can see the similarities between the social media pages. The same was said about the business focus, the website. There were a lot of similarities, and the judge held that there was clear evidence that the defendants had copied and tried to emulate the claimant's business and its brand. However, it looked at a lot of evidence and concluded that there was actually no misrepresentation. There was no evidence that consumers were being confused on the market, and there was no active deception. And for that reason, this case failed. And it's an important reminder that even where 2 brands might be very similar, and even where there is strong evidence of copying, this still might not be enough to get you over the line for passing off, and in particular misrepresentation. And the judge was quick to point out in this case that it might be unfair, but passing off is not a tort of unfair competition. The next case is Philip Warren and Son. So the claimant was a family-run business in the high-end kind of butcher market, and it operated on in the retail side in Launceston, which is a small area in Cornwall, and also it had a kind of wider wholesale business as well. And Lidl, who we'll hear a lot about today, used the brand Warren and Sons for nationwide for their meat products. The claimant started in the 1980s, Lidl between 2015 and 2020, and the claimant, after a bit of delay, initiated passing off proceedings against Lidl. Looking at the evidence, Lidl did accept that they knew of PWS, the claimant, but they did say they didn't actually copy or weren't inspired by them. When they ran their clearance searches, they saw that PWS didn't have a registered trademark, and for that reason, and a number of reasons, they concluded that there was no legal risk. So they went ahead and rebranded all of their meat products nationwide. So one of the difficulties in this case was that because the claimant was delayed in bringing proceedings, this actually meant that there was about 5 years of really strong evidence, a lot of evidence that they could have put forward. And the judge assessed all the evidence and concluded that because there was this 5-year period, 2 very similar brands, he would have expected for there to be a lot of evidence of confusion. And whilst PWS put forward some evidence of confusion, perhaps someone on the tech side could help out.
Has that gone away? No. Just pop outside. Don't know.
Perhaps it's telling us to go for drinks early.
I don't want to touch it.
Well, that's a little I love the idea I could maybe just touch that. Sadly not. Are you going to get someone to help us? That would be great. Okay.
Keep going.
I'll keep going.
Keep going. Otherwise, I can turn us around and those with good eyesight and just.
Hey.
Okay.
I can put my laptop up.
Try that.
I'll start. It'll be like charades.
Pictionary.
So so with this case, Philip Warren Sons against Lidl, there was some evidence of confusion, but not enough for misrepresentation, and various aspects pointed to this sort of being the case. They've operated at very different ends of the market. Lidl are obviously well known for their own branded goods and Lidl branded goods, and for this reason, there was no misrepresentation, and the passing off case failed. Which leads us on to our next case, which is Freddie. And this is actually quite disappointing that you can't see the screen, so I'm going to have to do my best to explain some very tight-fitting jeans on ladies' buttocks. Roland, well volunteered.
Next slide, please.
If you could turn around.
Glamorous assistant.
So the claimant had a jeans product called the WR Up jeans, and the defendant had copied a very similar version called the Hugs jeans. And initially, they did admit copying, and the initial case settled. And then they brought out a... there we go. Thank you.
Didn't want to miss that.
So the defendant copied this. They brought out a new version, but the claimant initiated new proceedings. And it was based on a few claims, but one of which was passing off. And they relied on various brand elements, including the shape of the false pockets, the badge on the back, and then that sort of cross strap that you see out to the top. But importantly, at this point, for these products, they were selling under different brands. So Freddie was selling under the WR Up brand, and Hugs was selling as Hugs. So that was obviously Hugs' main argument, that these jeans products were branded differently, so there would be no misrepresentation. But the judge actually sided with the claimant in this case, both on conventional passing off, which is where consumers are going to be confused at the point of purchase. And the reason for this was that even though the brands were different, the judge held that the elements that had goodwill, so the elements that I mentioned earlier, they were particularly strong and gave an indication of origin that they were the claimant's products. So for this reason, there was passing off in the conventional sense. But interestingly, in this case, there was also post-sale confusion, which is where even if there's no misrepresentation at the point of purchase, there could still be a risk that consumers looking at someone else wearing those jeans could be confused about the origin of those products. And it's quite important in the fashion industry. A lot of copycats will try and produce lookalike goods to encourage people that they are the luxury brands and sell them for a knockoff price. So this is actually quite an important judgment for post-sale confusion. And then moving away from the world of trademarks, the last case I'll quickly mention in this section is this case. The claimant had had registered community design and unregistered community design rights, both valid in the left shoe, and the defendant produced the shoe on the right. For unregistered community design rights, the difficulty with this is that you have to prove that there's been actual copying. And even though the defendant in this case, the evidence showed that they had bought a number of the claimant's shoes and had been inspired by those designs, they hadn't actually bought the shoe in question. And other evidence showed that there was actually an independent design process. And so even in this case where there was a clear intention by the defendant to produce similar goods, and it was inspired by the claimant's other shoes. In this case, there was no copying, and the unregistered community design case failed. So an important reminder of the limitations of unregistered designs. You need copying, and obviously the other limitation is that they're a lot shorter in time period than your registered rights as well. So now we've looked at the importance of registration, I'll pass on to Julia to look at some of the other issues when actually registering marks.
Thank you. Yeah, I think we can all agree that registration is optimal and very important. Let's all go and register our trademarks. But obviously, on the other side of the coin, it's still quite difficult to do. And I'm sure most of us in the room will have encountered, trademarks which are considered descriptive or non-distinctive or too non-traditional to be registered in some way. And this was the case for Off-White. So they sought to register this trademark, slightly stylized trademark that you can see at the top, in respect of various sort of consumer goods, so going from cosmetics to jewellery and various sort of homeware goods. And obviously, fairly unsurprisingly, received an objection that it's descriptive and non-distinctive, Off-White being a word which describes essentially the colour grey, and so could be descriptive of any of those goods. But by the time this case had got to the General Court, they actually took a slightly more nuanced view and said that actually, unless that word is, put it on screen so we'll quote it, so objective, inherent, intrinsic and permanent to those goods, it's not going to be descriptive. And so they actually reversed that decision and held that Off-White is sufficiently non-distinctive or inherently distinctive to function as a trademark, which was good news for Off-White. And I think it sort of increases the threshold of descriptiveness and non-distinctiveness, which is good news for brand owners with encountering those sorts of objections. Slogans also get those sorts of objections as well. So I think we can all think of examples of slogans being described as banal or laudatory or sort of just general puff. And that was the case for Oakley's trademark. So they have a slogan which relates to their sort of alternative milk goods. It's like milk, but made for humans. And originally received a non-distinctiveness objection on the grounds that it simply describes a product which is apt for human consumption, so just encourages people to pick up something that's made for them. Again, by the time this case got to the General Court, they decided that this was a case of a slogan which introduces a controversial and complex thought. So it's not actually just about saying whether something is, good for humans. It's saying, is the milk you're currently drinking bad for you, bad for the environment, morally bad, and is our product actually better ethically? So that provokes a cognitive process in the consumer and is sufficiently distinctive for it to function as a trademark, which is good news for protecting assets other than just your house brand, also slogans as well. Then, obviously, slogans, are on the borderline of sometimes people register them, sometimes they don't. But brands also have other assets like sounds, colours, patterns, and these are non-traditional trademarks, which are really important in the sort of weaponry of your brand, if you like, so that the items that consumers do use to recognise your products or your services. You'll have to imagine this one, but it's a sound mark which consists of a fizzy drink tab being pulled, then 1 second of silence, and then 9 seconds of a drink fizzing, which was sought registration in respect of cans and fizzy drinks. So unsurprisingly, this one failed because I think, it's, the sound is really a technical sound. It's a functional element of the goods, and it doesn't matter that that sound is made after consumption of the goods because they're so intrinsically and so associated with fizzy drinks. So that one did fail, but I think it's just an important reminder for brand owners where your marketing teams are using things potentially more on social media or other channels, and they're non-traditional. They're still registerable as trademarks, and you should really try and sort of beat your competitors to it and register them.
Thank you. Thanks, Julia. In an ideal world, obviously all marks would be inherently distinctive, but as we know, that's often not the case. And there is an alternative route to registration, which is the acquired distinctiveness route, which is where the mark has acquired a distinctive use through the extensive use that's been made of it. And so essentially the public's sort of been educated to see a particular mark and recognise a particular entity by that mark. In order for those sort of applications to be successful, there needs to be, the mark in itself needs to be a badge of origin. And simple exposure, and just because you're using the mark, is not enough, which unfortunately TEFL found out with this UK trademark application for a red dot, as you can see on the screen. So the inherent distinctiveness argument failed. The UK IPO was quite scathing, said that this mark had absolutely no trademark significance and was banal, so that was quickly put to one side. And the acquired distinctiveness argument also failed. I thought it'd be useful for you to see just some of the evidence that was filed. So you can see from the marketing, there's a bit of a sort of focus on the thermos spot, the technical nature of that red dot. And then also you can see the packaging where the red dot is actually cut out, so the sign is actually exposed as part of the packaging. So what went wrong here? I mean, these applications are all about the evidence. And here there was a high turnover of TEFL pans and cookware that were bearing the mark. There was a significant period of use of the mark over a long time. And there's also survey evidence that was submitted. And the sort of key point here was, had that sign been promoted in a way that was over and above it being a mere feature of the product? Coming back to the 2 points I mentioned earlier, the badge of origin point was key here. There was actually nothing that was filed that was really indicating that the red dot had been used in a trademark, a brand sense. And there had been criticism of the survey evidence filed also. The UK IPO thought that actually the general public might just be not actually associate with TEFL and just be reminded of it, which wasn't enough. The exposure point, I mean, TEFL had spent a lot of money on promotion, as you can see on the screen. They'd shifted a lot of products bearing that mark, but it wasn't sufficient. And this was all types of red dots. So there's red dots with T's in the middle and lots of different variants, and they were all considered, but it wasn't sufficient. And this is really for 2 points. Firstly, the indicator of heat point, as I mentioned earlier. It's really, a lot of the marketing was really focusing on the fact that it was achieving a technical effect. When do you start frying or cooking? You look at the red dot. And also promotional material references. Again, there was a lot of focus on it just being a technical feature and not actually reinforcing the brand sort of sense. In fact, the hearing officer also said, if there had been references to the pan with the red dot, that would have helped the consumer to understand that this was actually a trademark in a brand sense. And I think this sort of brings to mind the fact that often as lawyers we're not really writing the script, and it's important to try and educate marketing teams and the business about your marketing strategy, especially when marks like this one have a bit of a technical nature or functionality.
Thank you. So we've spoken about registering your trademarks, how to get them registered, and it's really important that you do. But we also need to think about whether you're registering the right trademark, because it's all well and good having one, but actually if you can't enforce it in cases where you really think you need to be enforcing your trademark, it's not much use. So this was unfortunately encountered by Decathlon. So this is an EU opposition. And Decathlon, the sportswear retailer, which I imagine most of us know, opposed this stylized trademark here. So it's sort of stylized infinity sign coupled with the word athlon and then custom sportswear underneath. Identical goods in those classes. Now the EU IPO held that Decathlon is weakly distinctive. Obviously, in relation to sports clothing and sporting goods. So it has a quite narrow scope of protection. Decathlon didn't file any evidence in those classes of enhanced distinctiveness, so it didn't broaden its scope any further. And also, the EUYPO looked at the stylisation of the trademark, the prominent device mark at the beginning of the trademark, which draws attention, and the overall impression, the inclusion of the slogan, the stylisation of the fonts, and concluded that they weren't similar. And there's no likelihood of confusion, and so both trademarks could coexist. Now, that decision didn't sit particularly well with me, just from knowing the brands, and I just think, you know, there is some confusion there, but the key takeaway being, if your brand or your name is weakly inherently distinctive, you know, it's something which is connected with the goods that you're selling in some way, you need to be filing evidence of enhanced distinctiveness pretty much all the time, and not treating cases as a slam dunk necessarily. Now, this case is slightly the opposite, so it provides quite a good contrast. So Sanacorp owns a trademark for Mayer, and it opposed Al Mayer, the slightly stylized trademark you can see below. Again, identical goods. And this opposition was successful. And this is because Mayer is replicated in its entirety in Al Mayer, and the EU held that the inclusion of the suffix Al wasn't sufficient to minimise the risk of confusion, and neither was the stylisation, which agree it's slightly minor. But the reason this case is interesting is because Mayer is descriptive at the EUYPO, so it's actually already been refused on the grounds that it means my in Romanian and a couple of other languages in the EU. So the applicant registered its mark as a German national trademark, and that's why this is important, because where you have a trademark which has been refused at the EUYPO on the grounds it's descriptive or non-distinctive, you should still consider registering that trademark in another EU member state where it's not, those objections aren't going to be raised, and that will serve as a really useful enforcement tool to keep the EU trademarks register clear of confusingly similar trademarks. So back to Oakley again. They've been busy. So they sought to enforce their rights in Oakley against a brand called Pure Oaty. And they were unsuccessful, and this is because, again, Oakley is quite weakly distinctive in respect of oat milks, and the suffix "ly" is fairly common. So the addition of pure and the lack of the L in Pure Oaty was sufficient for these brands to coexist. But one of the interesting things about this case is that Oakley relied on a trademark which it has in the blue colour scheme, and this was looked upon favourably in the comparison of the signs. So when the court was comparing the Oakley in blue with the Pure Oaty in blue, although there was no overall decision on infringement, the fact that the colour was included in both was looked upon favourably in the visual comparison. So the takeaway on that being, I suppose, if your brand has a colour which is it's wedded to and it uses extensively and it's really important, rather than just having the plain word mark or a black and white version of the logo, register it in that colour, because that will be looked upon favourably in future enforcement actions. So now we come on to highly stylised trademarks. So this is an opposition filed by Sony against GT Racing, and Sony owns, as you can see, this highly stylised device mark, which it says is the letters GT for its Gran Turismo brand. So you can see why GT Racing is of concern. Now, this opposition failed, and the reason why is essentially because that device mark at the top doesn't contain the letters GT. That's what the EU decided. So they said it's a hemisphere incorporating sort of various blocks of, ascending height. It won't be read as the letters GT, and so for that reason there's no visual, oral or conceptual similarity between the trademarks. Now this case is interesting because you would think, why doesn't Sony have GT registered? It's obviously a really important brand to them. And that's because Sony was opposed by a third party back in the 90s when it sought to register that brand and couldn't get the protection it wanted in its word mark. But actually since then, that right, the third party right that had been a basis of objection to its own brand, has since lapsed, it's expired. So the takeaway for brand owners here being, if you have a narrow sort of pool of rights, you should continually be looking to expand it if possible. So either by acquisition, could you acquire a third-party right which will strengthen your portfolio of rights, or when that right had lapsed, can you refile quickly after it's just expired and then expand your protection at that point? Another case of a very highly stylized mark, so identical outcome here. So this is Monster Energy, you'll recognise at the top, trying to enforce their rights in M against Merck. Their representatives very boldly tried to claim that this is a case of double identity. So the marks are identical. That obviously failed. So too did a likelihood of confusion, and that's obviously just because that mark is so highly stylized that it, they're not going to be confused even in respect of identical goods. The lesson here being, if you do have a very highly stylized house brand, consider whether, because sometimes they do use other brands, maybe on social media as a favicon or something like that. And if they're in use and they're less stylized, register those as well, because they will be slightly more useful for enforcement purposes. And finally, I just wanted to talk about Chanel and Huawei. So Chanel were unsuccessful in opposition to this Huawei trademark. And that's quite simply because the EYPO held you can't reorient the trademark and then say, oh, they're identical or they're similar. You're comparing the trademark as registered with the one that's being opposed. And here, obviously, Chanel's mark is a back-to-back C, whereas Huawei's is a stylized H, if you like. So they're not, they weren't confusingly similar. Takeaway being, if you do use your mark in other orientations, so if you're a brand, and you produce various merchandising goods like smartphones or duvet covers or something like that, where there's a pattern of marks and different orientations used, register all of those as well, and they will be quite useful enforcement tools for reoriented marks in future.
So it's not about just registering the right mark, but it's also then about preserving and maintaining those rights, which we're often faced when marks become vulnerable to attack and we're having to defend in revocation actions, and you're having to prove that your mark's been genuinely used. I just thought I'd flag the London Taxi case. It's actually a really good case. It just summarises all the case law on genuine use. So make sure you have a look at that. I'll just sort of go through some of the key points. I think they're just quite helpful to kind of put in front of mind before we go through some of these cases. So genuine use means actual use of that mark, not just token use. It must guarantee the identity of the origin of the goods and services to the consumer or distinguish them from another party. The use must relate to the goods or services which are already marketed or about to be marketed. I mean, internal use isn't going to be enough. And use must be by way of real commercial exploitation, which is dependent on the facts and circumstances. And that must be in relation to the market for the relevant goods and services. And there's no de minimis rule. So 2 cases that I just want to talk through about second-hand goods and accessory parts. The first one, in the case of Iowa, there were sort of various Iowa word, sort of in various styles that Iowa was trying to prove there was sufficient use of. This was a UK IPO hearing officer decision that then got appealed to the High Court, and the High Court was considering, was there genuine use of these Iowa marks. So Mr. Justice Mann didn't negate the fact that there can be genuine use on second-hand goods, but coming back to the original point, it's got to be a real commercial exploitation. It's got to be, the mark's got to be, creating or preserving a market share for those relevant goods or services. Just because you've got it on a second-hand good isn't going to cut it. And in this case, it failed because it was essentially really thin evidence. So sales were by persons other than the proprietor. There was some level of advertisement, but really they were just Iowa kind of branded goods that were on sale on like Amazon and eBay. And basically the level of advertisement was considered uncertain by the court. So there wasn't sufficient use in that case. So then we come to an interesting decision that was originally looked at in the courts of Germany and then was referred to the CJEU for a preliminary ruling, and they basically referred 6 questions, 2 of which sort of relate on genuine use, so I thought it would be useful to just highlight 2 of them. This was an international registration for Testarossa and also a German national mark. Essentially, the court was looking at the grounds of use in Germany and Switzerland over the relevant period, and Ferrari had sold a sports car with a particular sports car model. Sadly, I don't know it by hand, but they sold these cars like in the late 80s, and there was basically not many models kind of around since then. So the first question is on accessory and replacement parts, the second one, the sale of used goods. So for the accessory and replacement parts, the CJEU was thinking, look, if a product's no longer sold anymore, but then you've still got sales of trademarked accessory and replacement parts, is that sufficient? And in this case, Ferrari had used the marks to identify those replacement and accessory parts, and they'd also offered maintenance services for those flashy sports cars. And the CJU held that replacement parts that form an integral part of the goods, and I think that's probably the key point here, covered by that mark, are capable of constituting genuine use not only for the replacement parts, but for the goods that are covered by that mark. So in this case, replacement parts and also the car, which I think is quite an important point to remember. And then the resale of second goods, according to CJU, I mean, as you'll probably, you'll pick up a bit of a pattern here, but second-hand goods bearing a trademark does not mean in itself that it is capable of being used. It's got to go back to that essential function point. Are you preserving a market share by it? And basically that will now be considered by the High Regional Court of Dusseldorf. Ferrari will now need to bring sufficient use to evidence that the Testarossa mark has been used. And just two other quick points that I thought were interesting to note and to sort of put it into context. The fact that there were like hardly any, but 7,000 cars worldwide that have got this mark. That wasn't an issue. So again, remember the de minimis rule and maybe think about this context where you've got real luxury goods. There's not going to be that many of them anyway. So that's quite a good thing, I think, to put it into context. And also the fact that this is a sports car or a luxury car doesn't determine that there's an independent subcategory of goods. So it's still cars, even if it's just luxury or sports car, which is probably quite similar to, you know, jewelry or luxury brands. And conclusion, you know, don't write off second-hand goods. Don't put them on the shelf. You know, think about them and consider the qualitative nature of your evidence and whether or not you can evidence that sufficient use. And just one final case on this point. On a slightly separate tangent, we'll go away from second-hand goods for a minute. So Sony needed to prove sufficient use of its EU trademark for Vita, which for those of you that aren't big gamers is part of the PlayStation Vita console. And this is a really interesting point. Two things here. The use has to be in relation to what you've registered. And secondly, think about how you're actually promoting your service to customers. So 4 points here. Firstly, the registered goods here were basically data storage goods and then sort of audio or image carrier goods. But the promotion was about the gaming experience. Unsurprisingly, it's probably not the most sexy thing to be talking about, the data storage functionalities of it. But that was the real problem here, that, you know, all of the promotion and marketing was talking about the gaming experience and not about anything else. And the fact that it was multi-functionality was irrelevant here. And you know, you've got to think about the purpose and the intended use, and how that's being promoted to the consumer and what they are viewing. Again, just because you're using it isn't enough. And yeah, fame doesn't get you everything. Even if you're Sony, even if it's a really popular game console, that's not going to be sufficient. So I think going back to my first point, you know, think about how the marketing teams, your business are actually marketing these products that are, and consider that, because in the long run, these are the kinds of points that the court will be taking into consideration. Oh, sorry, quiz time. Hopefully that's...
Thanks. Yeah, I don't know how many to click before I give away the answers. So we'll just
Yeah.
we'll start with this one, just in case the next slide shows you what happens. I'm going to be really annoying, and when I ask you if it's registrable, I'd like people to stand up if they think it is, just to see if you're all paying attention. So this was a 3D EU trademark application by Guerlain, the luxury brand and part of the LVMH group, for the shape of its lipstick, its rouge lipstick product. So yes, this one was. At first instance and at the Board of Appeal, it was rejected, but the General Court overturned those decisions. It said that this was a distinctive mark. It was a very unusual shape for lipstick on the market. They said it didn't look like a lipstick product. It looked more like the shape of a ship's hull. Interestingly, I'm sure Guerlain was delighted. And also a baby's cradle. And it said another unusual thing was that the shape meant that you couldn't put the lipstick down. So the court commented that the shape at issue is uncommon for a lipstick and differs from any other shape existing on the market, and for that reason it was registrable.
Oh, this is me. Thank you. So Land Rover in 2016 applied for about 4 UK trademark applications for the shape of its famous Land Rover Defender. Here we go. Oh, I know, it's a bit of a cheat one. Everyone's a winner. So I think this case shows the difficulty, as we all know, with registering shape marks. But yeah, the UK IPO thought that the shape of the Land Rover Defender, as applied for here, did not depart significantly from the norms and customs of the passenger car sector. Jaguar Land Rover then appealed this to the High Court, and this was accepted partially for some of the goods. So not surprisingly, this wasn't allowed for motor vehicles, toys, vehicle parts, jewellery, but the applications did proceed for other sort of miscellaneous goods like bizarrely webcams, televisions, and balloons. So there you go.
Thank you. Okay. Right. So this is a trademark application filed by Lionel Messi, the football player, and it was opposed by a Spanish cycling company, and their trademark is Massey. So I think, shall we get you to do a stand up, sit down? So stand up if you think this trademark is confusingly similar to Massey. M-A-S-S-I, Massey, in respect of identical goods. That's wrong. I reversed the language on this and I didn't change the answer. So it was not confusingly similar, and that's because the court took into account Messi's reputation and said that everyone knows who he is, even though they tried to argue, Messi had tried to argue that in Lithuania they don't really watch football, they're more into basketball, so they don't know who he is. His reputation was actually what's called a well-known fact, so played into the conceptual similarity between the signs, or lack of, and so both could coexist. On a similar theme, so Miley Cyrus tried to register her name, which is Miley and Cyrus, as a trademark at the EUIPO in respect of audio recordings, DVDs, entertainment services, the usual. And that was opposed by a company called Cyrus, and they also had identical goods, prior rights. So would anyone like to stand up if they think that Cyrus is confusingly similar to Miley Cyrus? No? Okay. You're all right again. So the answer is they're not confusingly similar, and this slightly differs from the Messi decision because it focuses more on her name as well. So it says Miley and Cyrus are equally dominant and distinctive. It dismissed arguments to say that either she was known by her first name or first names are more prominent. And so because both are equally distinctive and also in light of her reputation as well, sufficiently dissimilar from Cyrus to be registrable for both of them. I'm just going to skip past the
What do we think? So, Exhibit A. So we've got Lidl's own brand of Hampstead Gin. Hampstead Gin had been sold by Lidl for over sort of 10 years, but in 2020 Lidl redesigned the bottle and the label. The owners of the Hendrix gin brand, William Grant, as you can imagine, weren't too pleased. And I should just actually mention they are a client and our team has been acting for them in this dispute. So big shout out to them. This is being presided over by the Scottish court. So what do we think? In respect of the bottle and the label, do we think that it's infringing? So William Grant alleged that the redesigned Hampstead Gin bottle infringed its registered trademark protection in respect of the bottle and the label, and that it also amounted to unlawful passing off. Law Clerk found that there was sufficient basis that there was visual and conceptual similarity between the mark and the redesigned Hampstead Gin. And William Grant was granted interim relief. The court held there was a real risk of harm to Hendrix's brand if Lidl were able to continue selling the redesigned Hampstead Gin bottle, and that was also confirmed by the Scottish Court of Appeal. So we will remain to be seen. It will remain to be seen how this case will develop, but everything crossed. I think it's a winner. Mm-hmm.
Thanks very much. And finally, we've got our favourite caterpillar, Colin, and his evil twin, Cuthbert. So I'm sure everyone here has seen in the press M&S, the owners of Colin the caterpillar, the cake, filed IPEC proceedings against Aldi's Cuthbert on the right. this was an action based on passing off and trademark infringement. So can you stand up if you think the passing off, sorry, this hasn't gone to trial yet, so this is a hypothetical scenario. Please stand up if you think an action for passing off would win. How about a likelihood of confusion infringement argument for trademark infringement? And the trademark, the words Colin the Caterpillar, and also the outside sort of packaging, a kind of photo of the outside box with the caterpillar inside.
But not that.
Not that. Not the picture of that. Yeah.
Yes.
Likelihood of confusion? No. Okay. I think we probably agree with you on that. And how about a unfair advantage 10.3 infringement claim? On the same trademarks. I think we're probably inclined to agree with you on this. The main factor in that 10.3, it would probably be their strongest argument, we think. But they allowed at least 5 other Caterpillar cakes on the market for some time before they took proceedings against Audi, and that's going to significantly impact their chances of succeeding in this case. We think overall they're facing a bit of an uphill battle.